Thank you. Justice DeWine, we are ready.
All right. Welcome to the Court of Capitania. Before we get started, I have a brief message to share with everyone. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of and others we are not fully aware of, which is why they are called implicit biases or unconscious biases. As participants in the National Moot Court competition in child welfare and adoption law is important, we all resist jumping to conclusions or acting upon personal likes or dislikes. Resist letting bias, prejudice, or public opinion influence your behavior inside or outside the courtroom. Treat all individuals with respect, regardless of ability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. All right, and at this point, the first petitioner may proceed.
Thank you, Chief Justice, Your Honors. May it please the court, my name is Corinne Bowden. I, along with my co-counsel, Caitlin Anuj, represent the petitioner, Ms. Destiny Knapp. I will argue that the termination of Ms. Knapp's parental rights was improper. My co-counsel will argue that she was denied due process. We would like to reserve 1 minute for rebuttal. To the first issue, Ms. Knapp respectfully asks that this court reverse and remand the decision of the Court of Appeals for 3 reasons. First, termination of Ms. Knapp's parental rights was not and is not in JK's best interest. Second, the trial court based its determination on premature and insufficient evidence of abandonment. And third, the agency utterly failed to provide statutorily required reasonable efforts in addition to specific court-ordered efforts to reunify Ms. Knapp and JK. Your Honors, the termination of parental rights is built upon the understanding that in doing so, a court is extinguishing a fundamental liberty interest, the right to parent one's own child. This decision is not to be taken casually. As the United States Supreme Court held in the 1982 case of Santosky versus Kramer, a parent and child share a fundamental interest in preventing the erroneous termination of their relationship. To that end, in Title 600, the Capitania Family Code outlines a 3-prong analysis that must be completed and satisfied before termination can be deemed proper. This 3-prong analysis serves to protect the interests of both parent and child in light of this shared interest. To my first point, Your Honors, and to the first prong of the analysis, the termination of Ms. Knapp's parental rights was not and is not in JK's best interest. In Title 600, Chapter 42, Section 600.10, the Capitania Family Code provides a list of mandatory factors that a trial court shall consider when determining what is in a child's best interest.
Well, what did the court consider here?
Your Honor, the court did not consider any of these factors, and if it had, it would have arrived at a different conclusion on this prong alone. But nonetheless, the failure of one of these prongs warrants the reversal of termination. Your Honors, among these factors include the relationship of the child with their parents, the custodial history.
So what's your strongest factor here? What's your best argument?
Your Honor, the strongest factor under Title Section 600.10 is the custodial history of the child. In this case, JK was only in agency custody for 11 months, and in Section 600.10, subsection B3, the statute presumes on its face that a child will be in agency custody for a minimum of 11 months. Your Honors, Ms. Knapp and JK were progressing on their relationship, as evidenced in the record at pages 2 through 3. JK was, as mentioned, in agency custody for only 11 months, and she was already in a legally secure placement. Ms. Knapp's parental rights were not an obstacle to that placement. Additionally, there were no obstacles.
It wasn't progressing when she stopped having any contact with him, was it?
Your Honor, it was not, and that's precisely the issue here. The agency stopped making any efforts at all to assist Ms. Knapp beginning in January.
What efforts did she make?
Your Honor, prior to the suspension of visitation, Ms. Knapp progressed significantly on her case plan and accomplished 7 out of the 10 objectives outlined for her.
What efforts did she make to keep in contact?
Your Honor, beginning on January 20th, 2020, as a record indicates on page 6, Ms. Knapp was precluded from having any in-person visitation with JK.
Was she precluded from calling, from Zooming, from doing anything else, writing letters? Did she do any of those things?
Your Honor, the record does not include any evidence that she did any of these things. However, the Supreme Court of Ohio in the 2014 case of N. Ray Doe stated that the failure of a parent to contact or send cards to a child or communicate with a child via phone is not dispositive of a parent's failure to communicate when the age of that child renders that form of communication meaningless.
Counsel, excuse me, what about the situation that in two different situations here, the trial court gave in to the mother and her attorney and sent the child back to her two separate times for almost like probationary periods, and both times she failed miserably. And one of those times, if my recollection is correct in the record, when she was driving, the child was with her. So, I mean, how much leeway do we give your client when she put the life of the child at risk multiple times?
Your Honor, the instance where Ms. Knapp was pulled over due to suspicions that she was driving under the influence, JK was not with her at that time. But okay, in regards to her efforts, Your Honors, the suspension of visitation at that point precluded any in-person contact. But the natural starting point in any serious attempt to rehabilitate a parent must start with the issues that led to the removal of that child to begin with. And as the DC Circuit held in the 1996 case of N. Ray DR, to ensure that reasonable efforts at reunification have been made, courts must expressly address the provision or the failure to provide certain remedial services and those for substance abuse in their decisions. And in this court, as evidenced on the record at page 24, the trial court did not consider that.
Counsel, why didn't your client have to make any proactive steps herself to get into drug treatment or do anything else?
Your Honor, Ms. Knapp is not relieved of any responsibility in this case. Reunification is a two-way street, but the agency, while agencies don't need to make Herculean efforts, they do need to do more than simply provide a list of case plan objectives to a parent and expect that they're going to be able to follow through on those. And that particularly applies when a parent is struggling through substance abuse illness, such as Ms. Knapp. Your Honors, parents share in the responsibility in availing themselves of appropriate case planning or case services once those services have been provided to them. And in this case, drug treatment services were not provided to Ms. Knapp.
But Counselor, how can you say in the midst of a pandemic, the length of which is of great uncertainty, how long was the petitioner going to wait to try to initiate contact with her child? How is it in the best interest of the child to wait for a potentially very lengthy pandemic?
Your Honor, JK was in a legally secure placement and she was doing well. And so the trial court prematurely terminated Ms. Knapp's parental rights before she had the opportunity to overcome the issues which led to the child's removal in the first place. And JK has been in agency custody for 11 months, but her young age at this point means that if she is in Ms. Knapp's custody, she is not able to help herself in the event that, excuse me, Your Honors. Your Honors, to my second point, the trial court based its determination on premature and insufficient evidence of abandonment. Thus, the second prong of the analysis is also not met. As page 7 of the record reflects, it's alleged that the agency filed its motion because the petitioner abandoned JK, but its January 9th motion came the day after drug paraphernalia was found in the home. Your Honors, drug paraphernalia and drug use is not among the section 600.07 grounds for a motion to file for termination of parental rights. Nonetheless, even if this court determines that this was not pretextual, Ms. Knapp didn't abandon JK because the agency created the circumstances which led to this period of abandonment, which led to this passage of the statutory period. Drug treatment services were required from the very beginning, as evidenced on the record at page 2. The case plan included drug treatment services. Visitation was suspended because of her continued and unaddressed struggles with drug abuse and substance abuse disorder, as evidenced in the record at page 5.
Counsel, when does the child's right to permanency balance into all this? When does that outweigh your client's rights here?
Your Honor, the two are one and the same. And in this case, the best interest doctrine presumes that the parent is the one in the best position to be able to care for their child. But in this case, part of the court's abuse of discretion was that it stripped away Ms. Knapp's parental rights before she had the opportunity to address the issues which led to the child's removal, and stripped JK of the opportunity to have a relationship with her mother. And so that too is not in her best interest.
Ms. Bowden, I would agree with you on your argument as it relates to her not having drug treatment made available to her in a timely fashion by the agency, but I'm having a very hard time struggling with the issue of her failure to contact in any way the child. You said that she knew the child was in a good home. How do you know that? Because she never reached out to Children's Services or the foster family to even know that her child was doing well. She didn't know JK was doing better.
Your Honor, while the petitioner did not reach out during that period, we know that JK was doing well because the caseworker testified that she was doing well in her current placement.
Counsel, we know that, but your client didn't know that because she wasn't in contact with the agency. That's my point, Counsel.
Your Honor, that's correct. During the suspended visitation period, the petitioner, Ms. Knapp, did not reach out to the agency, but the agency did not also reach out to Ms. Knapp. And because the agency has this statutory burden of providing reasonable services to a parent who is struggling, especially given the circumstances of the global pandemic, the agency should have nonetheless kept in touch with her and could have conducted more in-home visits or checked on Ms. Knapp more to make sure that she was doing well also.
Counsel, I want to ask about a question that kind of follows on my co-judge's question earlier. She has now been placed in 2 different foster homes. The record indicates that she has shown some attachment in the second foster home. So isn't there harm at this point? Your first prong was what is in the best interest of the child. If the child has had all of these issues with the parent, and it is the child's best interest, not the parent's best interest, as the lower court ruled, or at the appellate level, then how many foster homes does she have to be placed in before we say that the timing is right to terminate?
Your Honor, it is correct. The best interest of the child is what is foundational in these cases. And the length of time that a child is in placement, while it should be limited, it's not determinative. But the fact that JK was in this stable placement meant that Ms. Knapp could have had the opportunity to improve her at-home circumstances, overcome her substance abuse issues, and then provided a more stable placement for JK. And
I understand that, Counsel, but what I'm asking is the longer she stays in the second placement and continues to form those family relationships and bonds, then isn't that outweighing the interest of the parent to retain the child back or to get the child back? At some point, those two things will collide, it seems to me.
Your Honor, a parent and child, however, share this fundamental interest in preventing the erroneous termination of their relationship. And because a child is doing well with a foster family, we shouldn't let that supersede this fundamental interest that the two share. The relationship should not be terminated prematurely. And in this case, Ms. Knapp was never given the opportunity to improve. Your Honor,
Counselor, doesn't the very young age of this child increase the need for faster action, given the 3 years of age of this child?
Your Honor, on that point, we disagree. The young age of JK is helpful in this regard. One of the best interest factors concerns the age of the child and whether the child is at an age where it might be difficult to place them up for adoption. But here, JK is at most 4, and so she still has plenty of time before that is even a concern.
But what about her attachment with her mother?
Your Honor, the record on pages 2 through 3 indicates that Ms. Knapp and JK were progressing on their relationship. So there was a bond between parent and child, but because Ms. Knapp was precluded from any in-person visitation, they were not able to work on that bond further. Your Honors, the agency utterly failed to provide statutory...
Before you get to that, I need to understand exactly what rule you're asking us to write, because this is not, the pandemic is an ongoing thing. We're going to see other cases. So should we just say the 90-day period doesn't apply during the pandemic? Are you saying it doesn't apply when the agency doesn't make drug treatment available? Explain to me exactly what rule that you want this court to write. What is the determinative legal issue here?
Your Honor, the Capitania Family Code outlines this three-prong analysis, and all three prongs have to be satisfied. And even though one prong may have been met, let's
focus on the 90 days. I think you're saying, to me, that seems the biggest issue. So what should we say about the 90-day requirement?
Your Honor, Ms. Knapp's failure to communicate, Ms. Knapp was precluded from any in-person visitation. And considering the child's age, conducting phone calls with the child would have become difficult.
So I'll let you answer this question. So did we say in all cases during the pandemic that the 90-day requirement doesn't apply?
No, Your Honor, we're not asking that this court disregard that requirement, but we are asking this court to reverse the decision based on the fact that the agency didn't provide these reasonable services as it was statutorily required to do. For these reasons, we ask that the court reverse. Thank you.
Okay, whenever the second petitioner is ready.
Thank you, Chief Justice, Your Honors. May it please the court, my name is Caitlin Anuj, and I'm arguing that Ms. Knapp was denied procedural due process. Your Honors, this court should reverse the Court of Appeals decision and hold that Ms. Knapp was denied procedural due process for the following two reasons. First, the lower courts improperly balanced Ms. Knapp's interests.
What procedure was she denied that she was entitled to?
Your Honor, she was denied the procedure of an in-person hearing as opposed to a telephonic hearing, which did not sufficiently safeguard that fundamental interest.
Why is there a requirement of an in-person hearing? Where does that come from in the due process clause?
Your Honor, the due process clause of the Constitution says that an individual must receive due process of law. And by reading that phrase,
she had notice, she had a hearing. That sounds to me like due process. There's nothing in the due process clause that says you have to have an in-person hearing.
Your Honor, we disagree because in this case, Ms. Knapp's fundamental liberty interest was not adequately heard. In this case, the fact that it was only via telephonic technology did not allow Ms. Knapp to have all of the safeguards, which include...
So what did it have to be? Would a Zoom hearing have been okay?
Your Honor, an audiovisual hearing, such as via Zoom, would have been appropriate for Ms. Knapp to have her rights satisfied. There would also need to be additional safeguards in place for that to occur, such as having the witnesses show their environment to ensure that they are not being improperly influenced and that they are properly identified as well.
Counsel, as the Court of Appeals said, they compare this to an individual who's incarcerated. And those individuals don't have the right to come to court on PC trials. They're represented by counsel, have notice, and as long as they have someone there handling their case, defending their issues for them, they don't have to be in person. So how is this different than an incarcerated individual? Or we're going to have everybody coming out of prison every day for a permanent custody trial?
No, Your Honor, that is not the case. That's distinct from this case involving termination of parental rights because Ms. Knapp is not incarcerated. She was not stripped of those liberties. And so the fact that she was prevented from being able to have this in-person hearing because of a global health crisis should not be placed on Ms. Knapp's shoulders.
The Chief Justice asked the question very clearly. What was good enough? She had the opportunity to have a hearing. She had counsel. She had the ability to be involved in the communication for the case. How much longer do we have to wait?
Your Honor, in terms of how long we would have to wait, it would not necessarily be very detrimental to JK nor Ms. Knapp to have it wait, whether it be a few days or a few weeks or a few months, because JK was already in a stable placement and because Ms. Knapp would actually be able to have her liberty interest sufficiently safeguarded via either in person, preferably, or via audiovisual technology with the appropriate safeguards.
Counsel, what specifically do you think would have been different in this case had she had an in-person or video hearing? What did she miss out on specifically by having a phone hearing?
Your Honor, Ms. Knapp missed out on several things, which I can illustrate through the New Mexico Court of Appeals case, State versus Almanza. In that case, they stated that confrontation face-to-face serves a number of important purposes, including observation of the demeanor of the witnesses, impressing on the witnesses the seriousness of this matter, and assuring the identity of the witness and that they're not being improperly influenced. Your Honors, without being able to see the witnesses, the court would have no idea if they are who they say they are. Additionally,
is there any indication that any of that happened here? I mean, this is just kind of hype. There's no, like, what in the record can you point to that says that in this case, having a telephone hearing affected the legitimacy of the hearing, affected the trustworthiness of it?
Your Honor, it's true that there is no evidence in the record of this. In
So
fact,
we just presume prejudice? Is that?
No, Your Honor. However, the details of the telephonic hearing, and this may be a cause for concern, on the record on page 7, there's only a single sentence describing the telephonic hearing. Quote, following a fully telephonic hearing, the trial court terminated Ms. Knapp's parental rights. So it is not clear that any procedural safeguards were enacted, to preserve.
She was represented by counsel at that hearing, right?
Yes, that is correct, Your Honor.
Okay, so if there was something that counsel was uncomfortable with, counsel could have put that in the record, right?
Your Honor, not necessarily, because if counsel and Ms. Knapp were all via telephonic technology, it would be very difficult for counsel to be able to determine whether that be with nonverbal cues or verbal cues from Ms. Knapp in order to determine whether or not there's something wrong. Your Honors, the third factor of the Matthews versus Eldridge balancing test was improperly weighed by the lower courts. The government interest in this case is low because postponing the termination hearing would not have caused harm to JK. The government has an interest.
But does the government even know when they would be able to have an in-person hearing?
Your Honor, it is unclear when the government would be able to have the hearing. However, despite that fact, Ms. Knapp's fundamental liberty interest deserves to be sufficiently safeguarded. And so whether that be via in-person hearing following CDC guidelines, or whether that be via audiovisual technology, the court should have been able to offer those alternatives.
Help me understand.
I'm sorry, Counsel, just one quick follow-up. Is there anywhere in the record that your client and her counsel requested a Zoom hearing? Because you've said that a Zoom hearing, or maybe your co-counsel said, a Zoom hearing would have been okay. So why didn't your attorney, the attorney for the mother at that point, request that? Because I don't see that on the record. Respectfully,
Your Honor, it is the duty of the court to ensure those safeguards for Ms. Knapp. It is not Ms. Knapp's duty. The burden is not upon her to ensure that her fundamental liberty interest is being safeguarded.
Isn't it someone's burden that they think a trial judge is making an error to object and point that out so the judge can correct that? That seems pretty fundamental to our system, right?
That's correct, Your Honor. However, Ms. Knapp could not have known at the time. She is not an attorney herself.
But she had an attorney, right?
Yes, Your Honor.
And so this is not a case about ineffective assistance of counsel. So she had an attorney.
Yes, Your Honor.
So the attorney could have objected, right?
They could have objected, yes, Your Honor. However, considering the facts of the record and of this forum, it is still a cause for concern that there is no evidence in the record that any procedural safeguards were taken in this place.
Counsel, can I take you back to the New Mexico case that you cited?
Yes, sir.
I am struggling to figure out if that was presented. Perhaps I missed it. Can you tell me a little bit more about the facts in that New Mexico Court of Appeals case?
Of course, Your Honor. Considering that that was a criminal case, it was involving...
That was what I was wondering. Is that a criminal case?
Yes,
So
Your
is
Honor.
the right to confront a witness in a criminal context different than the right to confront a witness in a family law civil context?
They are not the same. That's true, Your Honor. However, the Sixth Amendment and the Confrontation Clause, the principle of that still applies to this case because termination of parental rights in a pandemic is a matter of first impression, and the most analogous situation to these circumstances is that of an incarcerated parent who is unable to attend. Your
Would
Honor,
an incarcerated
You're saying the Confrontation Clause applies in a civil case?
Your Honor, it does not apply directly. However, the principle of the Confrontation Clause and the Sixth Amendment is analogous to this current situation, especially considering it is a matter of first impression. Your Honor,
unlike a case in which a parent is incarcerated and that parent would be the only person not in the hearing, unlike everybody else, in this case, everybody was appearing by telephone. Everyone faced the same limitations. Isn't it more of an even playing field under these circumstances?
Your Honor, that may be true. However, considering the totality of the circumstances in this specific case, Ms. Knapp should be afforded the opportunity to be able to confront her witnesses and to be able to fight for her daughter, especially considering the COVID-19 pandemic and all of the circumstances leading up to this point.
Counsel, did she not have an opportunity to cross-examine the witnesses even over the telephone?
Your Honor, she may have had, it is unclear from the record, but she may have had the opportunity to do so. But considering that she was not able to physically see the witnesses and the judge, and for the judge to make that credibility determination as well, it is very difficult in order to gauge the witness's testimony, especially if the witness is, for example, reading from a script, having someone whisper in their ear. It is unclear whether or not this would be determinative in this proceeding.
Counsel, you keep on relying upon the fact that there may not be much of a record from the audio hearing. Should not her attorney at that point ask the court for findings of fact, conclusion of law, so that there would be a written record of what, in fact, the lower court used in making its determination?
Your Honor, that may have been an option that would have been appropriate at the time. However, considering the events that have unfolded, we still believe that a telephonic hearing alone, regardless of the facts that may have occurred, is insufficient to safeguard Ms. Knapp's fundamental right to parent. Your Honors,
is a telephonic hearing ever okay? Does that ever comport with due process?
Your Honor, it is appropriate in cases such as non-evidentiary proceedings where there are not circumstances involving witness testimony.
Well, I mean, if we say that you could never have a telephonic hearing, aren't we going to hurt a lot of parents who want to get reunited with their children?
Your Honor, not necessarily. We disagree because we are not asking.
Well, in this case, it hurts your client, but there may be other parents who would benefit from having a telephonic hearing, right? And be able to get their child back more quickly. Shouldn't they have that ability?
Your Honor, that may be a possibility when considering audiovisual technology. However, just via telephonic technology, a technology that is, quite frankly, perhaps outdated at this point.
The United States Supreme Court does their hearings through COVID, not with video, but by telephone. Are they violating the due process rights of litigants in front of it?
Your Honor, it is certainly a case-by-case basis. However, when determining a termination of parental rights proceeding and considering the gravity of severing the familial ties between mother and child, it is paramount that it be able to be both audio and visual rather than just over the phone and having that permanent tie severed.
Counsel, I'm trying to figure out if the issue is the right to confront the witness. The record, at least seemingly, is pretty clear and replete with instances of failures on the mother's part, drug arrest, et cetera, et cetera. I understand the DUI was dismissed, but the other issues, I'm wondering what she would have challenged had witnesses been appearing to have been coached or reading from a script or something, what would she have challenged in the record that was violated by not affording her the opportunity to see who was in the room with the witnesses?
Well, first and foremost, Your Honor, and this may be indirectly related, but the fact that the agency failed to make any efforts at all during the several months before this hearing during the pandemic shows that Ms. Knapp may be able to show the court how that affected her and how that lack of—
But that's on her. That's not calling into question the witness testimony. And your argument thus far has been that the witness testimony could have been perhaps impeached had she had visibility of the witness.
Your Honor, it is the witness testimony, but it is more than that. It is also being able to see the judge, and for the judge to be able to see Ms. Knapp. It is for her to be visible as well in order to make a credibility determination. To my second reason, Your Honors, the trial court's refusal to comply with Senate Bill 155 denied Ms. Knapp her right to fair procedures as required by procedural due process. I see my time is concluded. For this reason, we ask to reverse. Thank you.
Great. We'll take the respondents whenever they're ready.
Good afternoon, Mr. Chief Justice, Your Honors, and may it please the court. My name is Cliff Wood, and collectively with my co-counsel, Mr. Joseph Wester, we represent the respondent, the Capitania Department of Children and Family Services. Today, my co-counsel and I will show why the lower court's decision should be affirmed in their decision that the petitioner's parental rights were justifiably terminated following the finding of abandonment under the Capitania Family Code, which is the issue I will be arguing first. And second, my co-counsel will be arguing that petitioner's due process rights were not violated. Your Honors, this case is about protecting the fundamental rights of an innocent child compared to those of a mother who continuously fails in their duty to be a parent to their child.
But what about the government? Didn't the government fail here? I mean, you're pointing fingers to the mother, but all you had to do was get her into treatment. You couldn't do that.
No, Your Honor, the agency didn't fail in this particular situation due to a totality of the circumstance review of the agency's efforts during this period of time. Specifically,
also, you can hide it all you want, but the agency in this case clearly failed. We understand that families, parents don't have the sometimes intellectual capability or the knowledge of how to jump through the hoops of government. That's why we say the government must use reasonable efforts and do as much as they can. In this case, the government clearly failed to help this woman get into drug treatment, failed to explain to this woman what a no contact order meant versus no visitation. How do you get over that failure of the caseworker and the agency to help this family stay together?
2 points, Your Honor. First is the fact that the issue before the court today is whether or not the petitioner willfully abandoned the child. And to answer Your Honor's second point, recently in a case, Tennessee Court of Appeals case, In re Kalia, read the best interest in the child determination to have been found separate in determining whether or not the reasonable efforts of an agency was required when there was a finding of abandonment, which led to the termination of the parental rights.
But if the agency had done what it was supposed to do, how do we know we'd even be here?
Your Honors, on July 24th, it was determined by the lower court that the agency had complied with their duties at the record on page 7. And so,
that the lower court may think that, but I think that not getting her in drug treatment when you've been ordered to do that, I think that's a problem.
Respectfully, Your Honor, I can agree with that in the sense that there was a two-way duty, and a petitioner concedes that both the parent in this particular case and the agency had a duty in ensuring that the petitioner was able to maintain compliance with the case plan, which required her to maintain contact with the agency. So at the July 20th hearing, it was ordered to the agency to assist Ms. Knapp in maintaining and enrolling in an intensive inpatient drug treatment facility. 6 weeks during the pandemic is, relatively short period of time. And in the long haul of this case, it's been going on for 8 months. JK has been in temporary custody. And so the petitioner's pure lack of failure to reach out to the agency to establish as whether or not there was any room available for the petitioner to make.
So 6 weeks is a short period of time when it comes to the agency. but 90 days is a long time when it comes to the mother.
Your Honor, the statute requirement for the terms of abandonment require that their determination be in the
I
best.
can have it both ways. I don't see how you can say that, okay, this during the pandemic, this is really a short time, but and not apply that same rule to the mother.
Yes, Your Honor, that can be conceded, absolutely. That doesn't change the fact that the mother has a requisite duty as well as the requirement to maintain contact with the agency. The petitioner fails to reach out to JK for a period of 205 days following the January 20th hearing. Actually, the court counted from January 1st to July 24th in this matter, Your Honors.
Counsel, did the agency, though, do anything to help her potentially, set up Skype, Zoom, video, any type of contact with the child? I mean, was the agency reaching out to her at all during this period? Or were you just waiting for her to come to you?
There's nothing in the record to show that there was efforts by either party, Your Honor. And when there's a presumption of willful abandonment, the burden then, when it's been established that there is a presumption of abandonment, the burden then shifts to the petitioner to prove as to whether or not her actions were justified. And in this case, that can't be done.
Counsel, I think you're hearing us question that ruling of the lower court that there was in fact abandonment. Many of us believe that there was in fact not abandonment, but a failure of the agency, which I actually give a higher burden to than the parent, because the ability of the agency to have multiple sources of knowledge and a better ability to assist an individual person who's challenged with her social issues that she has. We're all aware she has a serious drug problem. And so I wonder, the 90-day rule seems ridiculous. The fact that the agency didn't for 6 weeks, that's a pretty heavy to overcome here, sir.
Justice Capizzi, with all due respect, the agency had maintained a relationship with the petitioner during this entire time. And respectfully, the caseworker had submitted on multiple occasions that she had felt the petitioner was complying with the case plan. However, at the January 20th hearing, it was established that the agency felt as though it was no longer reasonable that the petitioner could continue to comply with the case plan, and it was causing detrimental harm to JK, which is why the court went forward in their finding of abandonment. And to second that point, Your Honor, to follow up on that point, that goes back to Judge Gillespie, apologies, question to the petitioner as to whether or not the mother's interest or the child's interest, how they weigh against each other. And petitioner stated that they're to be viewed equally. That's not the case. The Capitania Family Code has been established that when the original biological relationship between the petitioner and the child cannot be met within reasonable means in a reasonable time, then it is to be determined that the best interest weighs in favor of the child in the light most favorable to them. And in this case, that's what we see before the court today. Petitioner has failed to provide evidence or facts that can dispute as to whether or not her lack of contact with JK was not willful, that there was an excuse for her lack of behavior. And that was the issue on cert before the court today.
Counselor, wasn't the ability to have supervised visits dependent on her completion of drug treatment? How would the parent in this case understand that she had the right to make any contact if she had not been completing her drug treatment as she had been instructed?
Yes, 2 points, Your Honor. The petitioner, while there was a non-visitation order established, many courts have determined that when there's a substantial or an impediment in the relationship or making the efforts of being able to make reasonable contact with the child, that is to be viewed in the totality of the circumstances. In matter of CBC in the North Carolina Supreme Court, as well as in Elijah B., it was determined that regardless of whether or not a parent was incarcerated or had other difficulties in reaching out to the child, that they still had a requisite duty within their means. So in this case, it's been established that the petitioner can maintain a job, has a car, and while it maybe could not potentially visit JK, still had the requisite duty to reach out to the foster family, the agency, and certainly had the duty to maintain contact with the agency as to comply with their case plan. Add the record at page 2, Your Honor.
Counsel, were either of those cases you cited in the midst of a global pandemic?
No, Your Honor, that is not the case. However, that doesn't change the outcome and the required duty of a parent in this particular case. If anything, it would heighten the fact that the petitioner should be interested in inquiring about the health and safety of the child and do whatever means possible to make sure that she could ensure that JK was doing well. The tolling order, additionally, is an issue that has come up.
Practically, what was she supposed to do? I mean, she couldn't do the drug treatment because she never got into it. She didn't have visitation. She couldn't, it was a 3-year-old kid, right? I mean, it's not like you can have a long phone conversation. So what should she have done?
Your Honor, the burden of, sorry, I thought I heard some. Your Honor, the burden of proof here is to determine, or is to show that the petitioner's conduct was not willful. And there's nothing in the record.
But you have to show abandonment. So what should she have done that wouldn't be abandoned? What could she have done here? What do you want her to have done?
Your Honor, in this case, the petitioner could have reached out to the agency to determine whether or not there was another way to comply with the case plan during the global pandemic.
Okay, so what would that have been?
That could have been submitting to the court multiple drug tests throughout the requisite time, while the agency had not an affirmative duty, but an obligation per the court order to assist Ms. Knapp in getting enrollment.
So she should have asked the agency, and maybe the agency would have said she could submit mobile drug tests, even though she obviously had a drug problem and she hadn't been given any treatment. That's what she did wrong here.
No, Your Honor, that is something that petitioner could have done to show that her conduct was not willful abandonment. And in this case,
who has the burden to show abandonment? Who has the burden to show abandonment?
The original burden to show abandonment is on the state, Your Honor, and that's been established.
So so she should have done what?
Your Honor, that the burden then shifts back to the petitioner to determine what she.
I'm not talking about burden now. I'm just trying to, in practical terms, when I write this opinion, I want to be able to, if I would rule for you, I want to be able to say what this poor woman did that she didn't, that she didn't do that she should have. So give me something that she could have done that I know that we would.
Yes, Your Honor. My apologies to that. I misunderstood your question. She could have showed that she reached out to the agency. She could have showed that she reached out to the foster family. It was clear that the petitioner was able to maintain a job. She could have reached out to the foster family to show that she had means to show financial support to the foster family. She could have checked on JK's health and wellness. Any of these number of facts could have been brought forth to show that she was actually impeded by the non-visitation order and COVID pandemic, and petitioner fails to do so in this case.
Counsel, had she sent a card or a balloon bouquet, would we be here? Would that have satisfied would that have satisfied you that she was interested and engaged enough to not have abandoned the child with one balloon bouquet or with one green card or something to that effect?
Your Honor, not necessarily. According to a case cited by the lower court in Ray Elijah B, that would appear to be a token visit. And so that wouldn't be the meaningful contact that.
But again, you told me earlier that case was not in the midst of a pandemic, so she could not have visited in person under some circumstances. The place where you could visit was it was not an option for a while. So I'm trying to figure out how many efforts would she have had to exhibit in order to establish non-abandonment?
Well, it's to be viewed in the totality of the circumstances, Your Honor, and based upon the facts that we have before us today, we have a petitioner that continues to engage in willful and wanton activity, which causes detriment and harm to the parent and child relationship. And so that is one strike against the petitioner in that regard. Second, the failure to comply with the case plan and maintaining contact with the agency and JK for a period of 205 days, Your Honor, also shows that her conduct was not due to a circumstance outside of her control. And so when you look at the totality of circumstances, it's very clear that the petitioner has not established their burden of showing that their conduct was not willful. It was a 205 days period where the petitioner could have reached out to the agency and determined whether or not there was another adequate means to comply with that court order. And she did nothing to show that.
But Counselor, what about the reasonable efforts that the agency is required to make in this case. Certainly in the midst of a pandemic, the agency has far more resources to conduct investigations, to make contact, to find people. Isn't the federal government and other stakeholders encouraging agencies to do everything they can to maintain parent-child contact even during the pandemic? Particularly given the young age of this child, doesn't it seem that the agency willfully disregarded their responsibilities here?
Your Honor, I see my time is going to expire. May I finish and potentially go over time a bit in answering your question?
Give a brief.
Thank you. At the July 24th hearing, Your Honor, it was determined by the lower court that the reasonable efforts required had been made. The agency had supplied a case plan, and a caseworker to petitioner to maintain contact to ensure that they were working hand in hand to ensure that petitioner was doing everything that she could to regain custody. For a period of 205 days, the petitioner failed to maintain contact with the agency, and therefore their duty was found to be established.
Thank you.
Thank you, Your Honors.
All right. Whenever you're ready, counsel.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the court. I am Joseph Wester, and collectively with my co-counsel, we represent the agency. I will be addressing the second issue pertaining to whether holding a telephonic hearing during a global pandemic infringes on a litigant's procedural due process rights, but more specifically, procedural due process does not provide for physical presence. This issue can be answered in two parts. First, neither the federal constitution nor the Capitania Constitution provide for a litigant's right to be physically present. And second, the lower court's determination to hold...
But the Constitution doesn't say anything about what due process means, right? It doesn't say that you have to have notice in the constitutional provision, but we know it's there. So the fact that it's not physical presence isn't in the due process clause doesn't mean a lot, does it?
Yes, Your Honor, and the only thing required under the Constitution is notice and opportunity to be heard, which is
where are those words in the Constitution?
Pursuant to due process, the 14th Amendment. But furthermore,
right, because we've decided that due process means that, right? So
yes, Your Honor, and the lower court's decision to hold the hearing telephonically does not infringe on the foundations of procedural due process. However, if this court does determine that there is a procedural due process issue here, the facts of this case do not warrant reversal because that hypothetical error would only be considered harmless error and not structural error.
Well, how do we know if it's harmless or not? I mean, aren't the concerns about telephonic hearings, the ability of someone to coach a witness, the inability to look someone in the eye, to evaluate their credibility, aren't those things that you really can't tell whether they happen or not? 2
points, Your Honor. Harmless error revolves around the fact of whether the telephonic hearing would have had a different outcome than the in-person hearing, and petitioner cannot prove that. And to the second point, Your Honor, that goes to this.
But again, this is my point, right? You can't prove, if no one is with a witness who's on the phone, you can't prove that witness isn't being coached, right? You can't prove that. There's no way to prove that, right? Absent affidavit.
Your Honor, that goes to the second factor of the Matthews balancing test, the risk.
No, I'm just talking about prejudice. How would you show prejudice if you're saying you need to show prejudice from a telephonic hearing? How could one ever meet that burden?
Your Honor, specifically, it would depend on the case, but the facts of this case do not show that any of the witnesses were coached, and specifically,
do the facts show that they weren't?
No, Your Honor, but also
no, because we weren't there, right? None of us could see it. We don't know what happened. That's the point.
Yes, Your Honor, but also in a telephonic hearing or in a person hearing, there are already avenues to determine the credibility of the witnesses pursuant to Federal Rules of Evidence 608. The petitioner could prove pieces of evidence like opinion, reputation, or specific instances of conduct pursuant to Rule 608 to determine the credibility of the witnesses. And petitioner has not put forth any pieces of those evidence to determine whether or not the witnesses were credible, which goes to show that the witnesses were in fact credible.
I'm completely lost. What pieces of paper would someone put forth to show they weren't credible?
Your Honor, specifically pursuant to Federal Rules of Evidence 608, a litigant can use opinion of a witness, reputation of a witness, or specific instances of conduct of that witness to determine if a witness is credible. And petitioner has not put forth any evidence of that sort.
But 608 doesn't have anything to do with whether or not someone should allow a telephonic hearing, right?
But Your Honor, under either circumstance, it goes to show that the credibility can be assessed in a telephonic hearing or an in-person hearing, which goes to the risk of erroneous deprivation, which is one of the Matthews balancing factors.
Well, I read over and over in opinions, Supreme Court opinions, how important the right is to be able to look a witness in the eye and see if they're telling the truth. Does that happen here?
In criminal cases, yes, Your Honor, pursuant to the Sixth Amendment, that is a right to confront your witness.
It's a right pursuant to the Sixth Amendment, but it's a right because we think there's a reason it's a right? Because we think it says something about credibility, being able to look someone in the eye.
In criminal cases, yes, Your Honor. However, there are specific ways that a petitioner can prove that, and petitioner has not done that. And furthermore, there was a low risk of erroneous deprivation in this case because petitioner was represented by counsel. In the case in Ray PJ, the Ohio Court of Appeals held that a judge's decision to hold a hearing without the petitioners present did not raise the risk of erroneous deprivation if that litigant was represented by counsel, and that's exactly what we have here in this case.
But Counselor, doesn't it make a difference that the petitioner in this case could not look the judge in the face to express her love and her commitment to her child? The fact that you can sit here and look us in the eye and we can look you in the eye, isn't that fundamentally different as an experience than being able to communicate over the phone your love and commitment to nurturing your child?
Ultimately, Your Honor, no. Pursuant to the Capitania Family Code, the actions of the parent at the court date do not matter. It's the actions of the parent whenever the court is not watching. Miss Knapp choosing to leave JK at home to go assault her neighbor. That's actions that we look for love and affection.
What about Miss Knapp's actions in presenting her own testimony to the court at the termination hearing? Those are the actions I'm referring to. Wouldn't those have been much richer and deeper had she been able to look the judge in the eye?
Depending on the case, it could have. However, the determination of fitness of a parent pursuant to the Capitania Family Code does not depend on the demeanor of witnesses. It depends on the actions that are taken by the parent. And when we look at the actions of Miss Knapp, it goes to show that she wanted to forgo her parental right, which brings me to the first Matthews factor, the private interests that are involved. And in this case, there are two private interests involved, both JK's and petitioners. The United States Supreme Court held in the case Santosky that a parent's rights are diminished when a state finds that there are grounds for termination. Specifically, the parent's own choices lead to the diminishment of their right, which is why
what you're saying is completely circular. I mean, we have to get what we're trying to decide is if there's grounds for termination. That doesn't mean they have less due process rights.
Yes, Miss Knapp does have due process rights, but we focus on.
But the Matthews Eldridge factors go to the amount of process that's due, right?
Yes, it does, Your Honor.
And we're deciding in this case what process is due to decide whether or not her parental rights can be terminated. You can't just assume that her rights are going to be terminated and say, therefore, she's due less process.
But Your Honor, petitioners
isn't that what you're doing when you're saying there's less process due because parental rights are being terminated?
No, Your Honor. We look at the balancing factor, which Matthews is a balancing test. We balance both petitioner's interest and JK's interest, but because petitioner's own choices diminish her own rights, we focus on JK's interest, and JK has an interest in both stability and permanency, and holding a telephonic hearing plainly promotes both of those interests of both permanency and stability, which is...
But Counselor, what was the rush? Wasn't the child in a stable placement? Wasn't she doing well in a stable placement? What was the rush here?
JK was in a place of temporary stability with the foster family, but that did not provide the permanency that was necessary. Pursuant to page 3 and 4 of the record, when JK has been moved around, JK has shown certain attachment issues that go to negatively affect her growth and their growth and development, which could ultimately cause a problem with their own private interest.
That was so in the past. That was so in the past. But what about at the present, at the time of that hearing? Where was the urgency given the stability the child was experiencing?
The court was the agency's position is that the determination of a telephonic hearing allowed both permanency and stability. Just being in a foster family provided that level of temporary stability, but did not provide the permanency of an adoptive family that an adoptive family could allow. So having a telephonic hearing gives a piece of paper that says either the parental rights are terminated or the adoptive family can adopt JK, providing a level of permanency that is not found in foster families. Which brings me to the—
It sounds like it was an expedient way for a child to be adopted away from her loving parent. In this case, the child was, as you've heard from Justice Dorvacek, the child was in a good foster home. They'd only been the second placement. In many of these cases, we see children placed in 10 or 15 different placements. Yet the purpose of all of what we do is to give children an opportunity to go back to their primary biological parent. And it seems that the agency rushed quickly because they found an appropriate adoptive home. I'm troubled by that.
Your Honor, the agency did not rush. Ms. Knapp was actually given a chance to take back custody of JK, and 10 days into that temporary custody, she decided to leave JK home alone while she was 3 years old and physically assault her neighbor, which led to—
Excuse me, Councilman. In 2018, 19, and 20 in this state of Ohio, in state of Captiva, the drug problem, the opiate problem has been so great. And we understand that individual parents who have drug issues take a lot longer to repair themselves than simply 90 days. So I know I brought in the question, but you're making light of the fact that this woman cared for her child, twice tried to recover, and yet the agency stopped, and you guys just did a simple telephonic hearing because it's nothing. But frankly, taking away parental rights is, as we know, has been labeled a death penalty in a civil case. And for being a death penalty in a civil case, you sure went pretty quick.
But ultimately, Your Honor, the telephonic hearing did not infringe on the foundations of procedural due process because petitioner was still afforded reasonable opportunity to be heard, notice, and was afforded counsel, which goes to the fundamental fairness of the case.
So so can we just get rid of in-person hearings from now on, just say we're going to do everything by phone?
No, Your Honor.
Even the pandemic's over?
This case is specific to the pandemic, and because we have the Matthews balancing factors—
People have less due process rights during the pandemic?
No, Your Honor, it's a balancing test, which actually brings me to the third interest in this case, in the Matthews balancing test, the state's interest. And one of the state's interest is the interest of the public. And using telephonic hearings during a pandemic plainly promotes the public interest in safeguarding public health because it aligns with the public health guidance to eliminate unnecessary travel and in-person contact.
So again, people have less so it's okay during a pandemic, it's not okay otherwise. So what you're saying is essentially that a parent has less due process rights if when the problems of the state happen to arise, there's a pandemic going on.
No, Your Honor, it's just specific to the Matthews factors and balancing
the Matthews factors. That's what we're applying, right? That's what decides how much process someone gets. So,
but that's why it's a balance.
I just want to make sure that that's what you're saying is that during a pandemic, those factors apply differently and people get less rights.
During a pandemic, there is another factor that is involved. It isn't applied differently. It's another factor that is added to the equation.
Okay, but the bottom line is during a pandemic, a person suffering a deprivation from the government gets less protection.
No, Your Honor, during a pandemic, there are different considerations involved.
But don't those considerations point to less protection? That's what you're saying, right?
It depends on the case by case. In certain cases, that might come out differently. But in this case, procedural due process provided that a telephonic hearing was proper. Which brings me to the second state interest in this case, JK's interest. And JK's interest was focused on having a stable and permanent life. However, furthermore, the hearing was ultimately fundamentally fair. The Michigan Supreme Court held in Dodge versus Detroit Trust that principles of fair play are not invoked when the complaining party participated in the proceedings, which is what happened here. In the New York Family Court held in matter of guardianship of Daley that when a parent is represented, principles of fair play are invoked. And
Counselor,
furthermore,
I'd like to address that point. You're placing a lot of weight on the fact that the petitioner in this case was represented by counsel. How can we equate being represented by counsel over telephone as the same as being represented by counsel in a courtroom when you can have immediate access to confidential communications with your client, when you have the ability to step out of the courtroom and have a conversation with your client? How are two people on two separate phone lines ever to have any type of client-attorney relationships in the same way they would in the courtroom?
Your Honor, it would ultimately depend on the procedures of the courtroom. Nothing in the record goes to show that the petitioner couldn't have stopped or couldn't have requested a brief recess to discuss with her attorney what was going on. But ultimately, there is no fundamental right to be physically present in a courtroom pursuant to In Re CG, an Indiana Supreme Court case where the state of Indiana created a standing order that did not allow parents' physical presence because of safety concerns. Similarly, the state of Capitania has created a standing order that didn't allow parents to be in a courtroom because of safety concerns, and because a telephonic hearing provides for procedural due process, we respectfully ask for affirmance of the lower court's decision. Thank you.
All right, thank you very much. Case will be submitted.
Chief Justice, may I proceed on rebuttal?
Yes.
Thank you, Your Honors. We have one point to make on rebuttal. Respondent's counsel points out that the actions of Ms. Knapp at the proceeding don't ultimately matter. However, this is simply not true. The ability for Ms. Knapp to be seen by the judge, to impress upon the witnesses the seriousness of the matter, and to be able to express the considerations and the circumstances that have occurred, and to express how much that she wants to see her daughter is critical to this proceeding. Just as Justice Capisi said, I apologize if I mispronounce, but it is the equivalent of the civil death penalty. It is irrevocable. You are unable to retrieve it again, and you are permanently severing this family's ties. So it is critically important. It is paramount to be able to have this mother be able to be seen and to have her fundamental liberty interests safeguarded. Thank you, Your Honors.
Thank you, everyone, for an excellent final round argument. I want to let the viewers know on Facebook Live that we are going to stop the live stream and the recording until such time as the judges have had a chance to deliberate and submit their scores. Thank you, everyone. The scores are in, and we do have, we are going to get ready to announce the winners, but I do want to make sure that we are recording that portion of it and we can get back onto Facebook Live. So that just takes a couple of minutes. So just give me a second and we will get to the awards.
You must all be pretty tired by this point of the day after 2 days of nonstop arguing.
So do we get to find out where you're all from now that we're done?
Don't know the answer to that question.
Okay, I guess we'll find out. Sure.
I think typically when they announce the winners, they also announce the school, or when they announce the awards.
I don't want to be the one to break that rule.
Okay, fair enough.
Same here.
But thank you so much for your time in judging. Thank you.
Caitlin, I didn't mention it, but you did a good job. Wait, so which was it? Who you did the rebuttal, right?
Yes.
Yeah, you did a very good job, because I wasn't paying attention to whether or not anyone had reserved time, so I messed that up. So you did a very nice job of dealing with that.
We are now live on Facebook, everyone. Welcome back. First of all, I just want to thank everybody for making this competition what we feel is a success. We got all the way to the final round, and we're actually running on time, which is miraculous considering technology. I want to compliment all of the judges and all of the advocates. The hard work that has gone into this competition has been evident, both in the preparation of the judges for the questions and the provocative issues that are brought forth in this emotional case, and the advocates who clearly all 26 teams that have been involved have been very, very well prepared, took this very seriously, whether it's virtual or not, and we appreciate all of your professionalism in the way you've handled it. So without further ado, I am going to announce first the runner-up team, and I do have the awards here that I would normally be handing you in person, but they're quite beautiful, so I'm going to hold them up. They will be first engraved with your team and school's names, and then they will be shipped out to you when given the opportunity, when we have that opportunity. All right, so the 2021 national runner-up of the National Moot Court Competition in Child Welfare and Adoption Law goes to Widener School of Law. Congratulations.
Which one of you is that? We don't know.
Respondent.
Oh, I'm sorry. I didn't hear. Okay. Thank you.
And the 2021 national champion of the National Moot Court Competition in Child Welfare and Adoption Law is Florida State.
Yeah.
Congratulations. The team will get a plaque with the names of the advocates involved, and the school gets a cup, all provided by our sponsor. Thank you. And then lastly, we announced the overall best advocate for the final round. That person will also get a plaque. I'm taking them all out of the plastic. It's a beautiful plaque with a gavel. And the best advocate for the final round is Caitlin Anuj. Congratulations, Caitlin.
Thank you.
So that concludes this year's National Moot Court Competition in Child Welfare and Adoption Law. Thank you again. I hope we see you all back next year. Whether it'll be in person or virtual remains to be seen. But what I hope is carried with you is the experience and the opportunity to become better advocates and better lawyers. Thank you, everyone.
Thank you. We appreciate everybody's effort in this competition, and we're very grateful to have been able to participate. So thank you for all of your efforts.
Definitely.
You all were great.
Thank you to you, Jennifer, for putting it all together and staying on top of it. Capital Law School has been represented extraordinarily well here, so thank you.
Thank you, Dean.
Great job, Caitlin. You really knocked it out. Thank you.
Thank you so much.
Congratulations, everyone.
Thank you all.
Thank you very much.
You're welcome. Congratulations.